Are you ready? Aaron, you ready? All right, let's get this September meeting of the Tennessee Real Estate Commission underway. Can you?
Yeah, we can do all sorts of things.
Okay. All right, Ms. Maxwell, if you'll read into the record the public disclaimer and then call the roll, please.
Will do. Notice of the September 5th, 2018 meeting of the Real Estate Commission, including date, time, and location, has been noticed on the Tennessee Real Estate website since November 1st, 2017. Additionally, this month's agenda has been posted on the website since Friday, August 31st, 2018. Commissioner Gary Bloom. Commissioner Rick Douglas.
Here.
Commissioner Marcia Franks.
Here.
Commissioner Diane Hills.
Here.
Commissioner Johnny Horn. Commissioner Austin McMullen. Commissioner Fontaine Taylor.
Here.
Commissioner Bobby Wood.
Here.
Chairman John Grease.
Here.
You have a quorum.
Thank you, ma'am. Mr. Douglas, would you lead us in an invocation and then the pledge to the flag?
Yes, sir.
Thank you.
Pray. Father, thank you once again for allowing us the privilege to serve our citizens of the state of Tennessee. Lord, we ask you that you would give us wisdom and discernment so that we can make good, fair, and right decisions. Father, give us safe travels as we go back home today. We pray it in Christ's name. Amen.
Flag of the United States of America and to the republic for which it stands, one nation, under God.
Now Bobby's going to sing the national anthem.
And no one has taken a knee.
And you're going to change one burrito into 7. All right.
Can't wait to see that.
All right, next up is to approve today's agenda. You received it by email. Any additions, deletions? Ms. Franks.
I would like somewhere for us to talk about Arello, just a short little something on Arello.
You're going to put that under commission discussions?
Okay. And then I'd like for us to also talk about the October meeting,
Okay.
to get some info on that.
We'll put that under commission discussions as well. Ms. Taylor, did you want to add a little thing under education?
I want to talk about our education.
Pull that microphone closer to you.
I want to talk about reciprocating other states in education. I just want some information on that, please.
That under the education director's report. Anything else, commissioners?
And Chairman Grease, maybe I could just give a small little update on that auction task force that y'all were so nice enough to vote me on to. So.
I understand you're doing an excellent job on it.
Yes, well, yeah, we are. Awesome.
I do note under commission discussions that we rolled forward the election for chair and vice chair, and I again propose that we roll it forward. And at some point, we'll have a full quorum. We can get that handled. We have a full quorum, but I mean full body present. So without objection, we'll roll that to October at this point. Is that okay?
Yes.
Any other changes? All right, with those changes and frankly additions and deletions to the meeting.
I was going to just make one note, and we can discuss this when it gets here. You had asked for more additional information on the medical waiver request that we have on the agenda, and we had reached out multiple times to get the additional information, and we did not obtain that. So it was left on the agenda, but we do not have an update there.
All right, commissioners, you want to just address that when we get to it, or you want to take? Okay, keep that update in mind. All right, let's vote on the agenda as amended. Those in favor of the agenda as amended, vote aye.
Aye.
Those opposed, no. The agenda is adopted. All right.
Can we make a motion on that one?
Yes, we did. Ms. Hills made the motion, and Ms. Frank seconded. thank you both for cooperating.
Yes.
We have such quiet voices.
Well, maybe it wasn't you. All right, approval of minutes of the August 8th meeting.
Motion to approve.
Motion
Second.
to approve by Ms. Hill, seconded by Mr. Woods. Discussion on the motion. So I only have just a thought about this. Originally, that agenda, and maybe when it was published, it had a formal hearing to follow on the second day, as I recall.
It did.
Yes, and it got continued until November.
But do the minutes reflect that we didn't actually have that hearing, that it got continued?
No, but we could add that at the bottom, that the formal hearing was continued until.
I'd like to do that, just so people, if they're really following a paper trail, they have something to follow.
And whether they're continued or not, that needs to be a part of the minutes.
I think so.
And I wanted to say that I was very appreciative that the pages are numbered. The other things that we get to, I know the education is numbered, but some of the other things, especially the legal reports, if we could get those numbered, that would be great for future info.
All right, let's vote on the approval of last month's minutes. If you're in favor of the motion to approve, vote aye.
Aye.
Those opposed, no. That motion passes unanimously.
abstain,
And
because
this,
I wasn't-
it passes on a 5 yes, 1 abstention vote. Ms. Taylor abstains. All right, we're on to the Education Director's report. Mr. White, good to see you.
Good morning, Mr. Chairman, members of the Commission. Glad to be here this morning. We'll move right on to the education report. Here before you is the education agenda, and I want to submit these to you for your approval. I have reviewed all the providers, instructors, and education courses for S1 through S25, and I submit those for your review and approval.
All right, Commissioners, any particular course you'd like to pull out before we take a motion on this? Mr. Woods?
I was just looking at, I guess it's the second page, and it's the Greater Tennessee Chapter of Appraisal Institute. And as I read the description of just kind of like this seminar provides an opportunity for appraisers, real estate brokers, mortgage lenders, and lawyers to meet with professional peers during an open discussion forum covering several real estate appraisal topics. So let's get together and talk. I mean, is this almost like getting together for a social time, or what is? I didn't understand that.
Commissioner, it's more of a seminar type setting, but it is a yearly, annual world. They call it the symposium, Fall Real Estate Symposium. So it is a seminar type format, but they have some fairly heavy hitters in there this time, I think, as you can see from the list of instructors or speakers. So no, it's really, it's not just a get together, but it is a formal type educational review.
But it's maybe like just one big classroom, and then these people are taking turns talking.
Yes.
I can only relate it to what I do as a realtor. When we go to our convention, we have a bunch of speakers, but we have a bunch of different rooms, and you go to different places. But this is just one big room, and
this
then
is much
they
more
just keep bringing them
structured in that I envision it to be a large area or area where they can have this event. And each one of these speakers has an individual expertise to speak on, whether it's law or appraisal or, Commissioner Schroer is the Tennessee Department of Transportation Commissioner. So he'll be talking about issues related to transportation as it relates to appraising of properties and real estate and that sort of thing. But each one of these individuals has an expertise that they bring to this event.
So I have a question on that same one, too. So I looked this up because I'd never heard of the Greater Tennessee Chapter of the Appraisal Institute, and it's an education company. It's not an appraisal group, or it is. They totally do education. And so I was wondering, since this has to do with appraisals, and this is also, it's located in Cordova, Tennessee. I also wondered, have the appraisal commission also approved this class? And I was wondering, why do they need our approval if they have the appraisers' approval? Did they get it, or were they denied?
I have no information on that, but since we're sort of apples and oranges as it relates to appraisers and what we do here in the Real Estate Commission, but I assume that they're endorsed by the appraiser commission, and that all of these individuals. I haven't heard anything to in the contrary.
And so all of these, like Tony Garantana, he's like the biggest developer in Nashville.
Right.
And these are some big, high-hitting people. So have they agreed to appear at this symposium?
Yes.
To your knowledge? Okay.
Yes, and the materials that I received, that's what I said, it was a structured sort of environment with each speaker having a professional expertise, and I'm sure that Mr. Garantano will be talking about real estate development, if you will. So each one has their own sort of corner of that universe.
Marcia, can I follow up with that? The name of that entity doesn't sound like a for-profit organization. It sounds like
it's like
an institute.
CLI. It's like it's a school. They teach classes on appraisals.
But it's similar to CLI?
Yes.
Okay, so Professional Trade Association.
Well, Continuing Learning Institute is CLI, and so they teach. They teach other things other than real estate, actually.
Really? That's an odd name.
They're not a new provider. They've had this particular event, I believe, ongoing for some time, and that it is true. They've been a provider for several years.
Hey, do you have a motion?
Not yet.
You got one now. Motion for approval.
A motion by Mr. Wood, seconded by Ms. Taylor. The courses S1 through S25 be approved per the recommendation of our Education Director. Further discussion? Let's vote. Those in favor of that motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously.
Is this the proper time to
Not
ask?
quite. We've got to get instructors.
All right,
Well, then
okay.
Let's get these instructors. All right, Mr. White.
Thank you, Mr. Chairman, members of the Commission. Yeah, we'll continue on to review of the instructors, and I believe I've also prepared a document there for you, the instructors' biographies, so you can view that, and I would submit these for your approval.
The chair would like to get a motion that does not include the last two listed on the report, and we'll talk about those separately.
Move to approve all but the last two.
Second.
I'd have a motion by Ms. Frank, seconded by Ms. Hills, that the instructors recommended to be approved by Mr. White indeed be approved. If you're in favor of that motion, vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Now,
Mr. Chairman.
let's get on to charity fail. Mr. White?
Yes, sir.
Wait a
Ms.
minute, what?
The very last part.
Of this report.
Oh.
Yeah.
Okay, got it.
Okay, got it.
Yeah.
Jeremy, continue with charity fail.
Yes, please.
Yes, I was presented with this both by the application and the documentation that goes along with it, and sort of a request by the Success Real Estate School that this individual be reviewed because they bring a lot to the table, and I tried to relate some of that here for the Commission. However, she only has 4 years. Well, first of all, the application that they're wishing that she could teach would be pre-license courses, one 60-hour course, one 30-hour course. The 60-hour new principals course requires either that they be a broker or that they be an affiliate broker with 5 years experience. In this case, the individual, although she comes highly recommended, she only has 4 years. She's into her 5th year by a month. but she only has 4 years. So, I just told them I'd bring it to the commission, let you review it. Again, she has some great, I think, potential, and also they would really like to have her to do this course, and that's why it's here before you today. I just couldn't approve it because she did not have the requisite. Well, the law requires for a principal 60-hour course that they have 5 years experience, and that they be approved by the commission. If they're a broker, they can teach the course, but when they're an affiliate, as I think she first got her license in 2014, then that's something the commission would have to review and approve.
Did you say it was a statute that says this?
Yes.
So
Statutory, and I believe it's regulatory as well, but I defer to legal, but that is the case.
So what I'm not understanding is she's not presented a class. You said pre-licensing, but she didn't give you a syllabus. Is that correct?
No. Everything was presented to me properly. The
Okay.
application, all of her credentials. She has
what are her credentials, since we don't know what they are?
Well, I tried to outline it here, but she has.
Just said credentials.
Oh, sorry about that. She has a 2-year degree, I believe, in a summa cum laude degree in design. I believe that is dealing with office design and or that sort of background. She has been involved in training, mentoring her folks that she works with at CrowdLike. They have presented to me that they, with a letter and so forth, that this is an individual with a lot of gumption, a lot of get-go, and they'd like to see her do well in the industry, but they want to see her get this if they, again, it's commission's approval or not.
Mr. White or Ms. Matlock, I don't think we have any latitude in this, do we? If the statute clearly says 5 years.
1260-05-04.
Before. It's a rule, so it looks like.
What is that rule again?
It's on page 105. Specifically, it looks like we're looking at 1260-05-04-1D. It says that they need to have at least 5 years of experience in the subject of such course. So let me look at the statute really quickly. I would assume that the rule would be controlling and that they would need to have 5 years of experience before teaching a principal's class.
I move that we not approve this person.
Second.
Discussion. Now, with that, we'll vote on the motion in just a second, but she could easily, I would think, get a broker's license in 30 days or less, and then she would be okay. Is that your understanding, Ms. Matlock, as well?
If she were to complete the course?
If she were a broker, if she had a broker's license, then she could teach.
Yes, you could.
Yes, that's correct.
Okay, so there's an opportunity for her, but at this point, I think our hands are pretty well
Out of our
tied.
hands, I think.
The motion on the floor is to deny the request, and this may be Mr. White's request. I'm not even sure whose request it is, but I think we have to follow the law. Let's vote on the motion. Those in favor of that motion vote aye.
Aye.
Those opposed, no. That motion passes, and the application is denied. All right, Eric Kistner, what's new, Mr. White?
Thank you, Mr. Chairman, members of the Commission. This was continued from and held from August, and it's essentially Mr. Kistner is starting a new provider, and he would Real Estate Academy, and he is offering that he has the requisite background and skills to do that. And from last month, I believe Commissioner Hills had asked us to continue Mr. Kistner. So since he was putting himself out to start a new provider, to become an instructor as well, and offering courses, then all of it was held pending today's discussion. And I assumed that Commissioner Hills had more to add, but regardless, I've corrected or added to my biography in showing that he did not currently have an auctioneer's license or a contractor's license. He did have back in 2006 to 2016 and 2012 to 2016 respectively, but that he is a broker and he is a founder of Bridgepoint Real Estate and Auction, and he is a managing broker of 4 realtors at this time.
And what class refresh my memory, what classes was he wanting to do?
It's on
It's just for a provider, or?
Yes, ma'am. Well, he's starting.
Okay, I see.
I would like to ask a question. Why does he not have those 2 licenses? Did they lapse or what?
Contractor's license, and what was the
And
other
the
one?
auctioneer's license.
As far as I know, he just let them go to start, I guess, or to have more to do with his broker, his firm.
I think it would be nice to know if he did have them and he doesn't have them, whether there was a problem or just he let them go.
I'd have to say that he wouldn't have put this in writing that he formally held these, but I could certainly check on that.
And he's had the class to become a teacher?
Yes.
Okay.
Well, yeah, he's good in all respects, but we wanted to continue with a little bit more detail on his biography this time.
Go right ahead.
And so just to clarify my memory, because you just said it again, whatever the company name and auction, founder of.
Right.
But we clarified that last month, that that's no longer the name of the company since he does not hold the auctioneer's license. Correct? Is my memory right?
Yeah, I believe the name now, we can look it up.
I was thinking we did that last month, because that was another thing that it said Bridgepoint and auction.
Point real estate said of, yeah.
So, Mr. White, if we approve everything possible today, do we approve the entity? Do we approve the instructor, and we approve the courses that are outlined here, or do we have to approve Tennessee Real Estate Academy as a? Is that done?
Mr. Chairman, as a rule, when you approve the courses, then the providership will, as a new provider, will become approved because there's no application process for a provider as such. The background we've looked at, the courses are fine, everything is in order before you today. So if you approve the courses, it will approve the providership and approve him as he is the contact person and he is the instructor for those courses.
Thanks.
I don't want to put Commissioner Hills on the spot either, but I certainly don't know this person, but he is from the Northeast Tennessee Association, and he was president last year. Is there any direction that you can give us, Diane? Rather not.
I'd rather not.
Okay.
Thank you, though, for the opportunity.
So there are 5 hours of continuing education here for navigating the world of multiple offers. A 2-hour course, part 1, and a 3-hour course, part 2.
Right.
Just on the surface, I think Bobby Wood could teach that course and everything you need to know in probably an hour. Do you I mean, you've looked at the syllabus and you're comfortable that there's that much material to take 5 hours?
Yes, sir. And what was sent to us, Mr. Chairman, that he, the timed outline showed that, yes, there would be that, the way that they have set it out and structured it.
Thank you. Ms. Hills.
So, and I'm going by memory, and I haven't gotten in my book, but so we don't have, so when a school is set up, we don't have jurisdiction over the school or whatever. It's just over the instructor, correct?
We have jurisdiction, but the way that again, deferring to legal, the way that the law is set up, there's not a lot of enforcement power over the provider. Rather, it's over the courses and how they conduct those courses. So if they don't do certain things pursuant to the courses in the rules and the law, then they could lose those courses, and thus that's the reason for their business. So
From a licensing standpoint, the courses are licensed and the instructor is licensed. The provider is in our system, but they do not hold their own license.
they are registered, though. Yes.
Yes, they have to register.
Ms. Taylor?
Well, I was just thinking, since it seems like we have some places that are still missing in answers for this gentleman, including the proper name of his company, if that's still the company name, is that a problem for us in voting on something that with wrong information or possible wrong information?
What part of the information is incorrect?
I think Diane brought up the point that Bridgepoint Real Estate and Auction, that it's not and auction anymore, and then
Or if the broker doesn't have the auctioneer's license.
So do you have to have a license? My company is Franklin Realtors. Could I be Franklin Realtors in auction and hire Bob Parks, who has auctioneers, do those auctions for me? I think that's done. So I don't think
As long
there's.
as you have a principal auctioneer.
Oh, you have to have a principal auctioneer.
And if they're going to auction real
use that.
estate, it also has to have a real estate license.
He used to do that too. That you were.
I get squeezed.
so my question, is that a problem?
Well, that's each individual commissioner's decision at this point, I think.
Well, if you have to have a broker though, that's an auctioneer, do they have one?
I mean, I think what's in front of us, are you okay approving an instructor? Are you okay improving courses?
Yeah.
Okay, the education director is recommending approval for both, is that correct?
Yes, sir. From what I've been submitted, I believe that they are entitled to that.
I'm going to move to approve.
Second.
Motion by Ms. Franks, seconded by Mr. Douglas. Further discussion.
I still just have I don't have a warm fuzzy, and I don't know. I can't put my finger on it. I think that the point was made up that just made me think a little bit. Why does this person not have it was the contractor license, and what was the other one? Was it the auctioneer license? Why don't they have it? I would just kind of like to know that. And I know he just said he had it. He used to have it. That's just and I know you don't have it, so you can't just reach and grab it.
Right. I'd like to say, though, formerly in my past lives, I was the attorney for the Contractors Board, attorney for the Auctioneer Commission. It is possible, for anybody to get out of that business, if you will.
Exactly.
And the fact that the individual, if there were issues, and they made it clear, though I didn't make it clear, it's my fault, last month, that it was a former license being held. They gave us the dates and indicated by their submittal that they no longer had them, but they're holding themselves out in their resume that they're proud of that. They put it out there. So if there was an issue, then I think we would have discovered it, or that, our sister agencies, I believe I would have heard about it as well. But I can take it forward, whatever the commission desires. But at this time, I didn't see anything that would hold them, and I could not hold them back.
I'm gonna try this again. I just there's something I don't feel right. I'd like to amend the motion to defer it one more month until we can get the answers about the contractor's license and the auction license, and get the exact name of the company and get it on here right. And that would be my motion.
Heard the motion by Mr. Wood, second by Ms. Taylor. All right, let's talk about that for a minute. Mr. Douglas.
You want to talk first?
You go right ahead.
Mr. Chairman?
No, you go.
I'm wondering about relevance here. We have a lot of people teaching courses that don't have an auction license or a contractor's license, and the courses that I'm looking at here, there's no auction course here. There's no contractor course. They're all, pretty much your standard, 60-hour pre-licensed, 30-hour new affiliates course. Those types of things are all real estate related. He has a real estate brokerage license. My question is about relevance. Is it really relevant? I tend to agree with Mr. White here, is that it's just part of his resume. Who cares if he's an auctioneer now? But it was part of his resume, something that he was proud of. He started an auction company way back when, and maybe he doesn't own that auction company anymore. Maybe it's not an auction company. It's just pure real estate now. But it's just part of a resume. He also has a degree in economics. I'm looking at him on LinkedIn here. Economics and political science. He seems to be an educated gentleman, and I think probably someone who meets the criteria here to teach these courses.
Other comments?
Well, I think my feeling is similar to Bobby's, is that when we have information, it should be correct when we vote on anybody. And I'm Bobby. That bothered me, why he doesn't have those licenses. Could be something very simple. Okay, I'll let him go. But since the name issue came up too, I think we need to be careful in voting on people for the right reasons with the right information, not the wrong information.
Part of that, I will just note, is on our end, because the last month that he came up, the way that it was worded was incorrect, and that was something that was on our end that we didn't put it, that it wasn't put in past tense the way it should have been, the way it was reflected on his resume. And that was on us. So, and then, potentially his firm is now Bridgepoint LLC. It's not an auction. And so I didn't personally review his resume, but I don't know, in our system, it is not auction.
Right. And to follow up on that, the previous biography that I gave, the only thing I left out was that these dates that was inserted in his resume. So I knew from the discussion from last time that needed to put that in so you'd know that he formally had it. Now, in going along with that, he's holding himself out to have had these licenses, so he is proud of that. Now, so I don't believe you have any issue there, and there is not an issue as to the name either, because on his resume he was the founder of this company, and so he was Bridgepoint Real Estate and Auction when he founded it. But now it's a different name now in the system as an LLC. So that being said, I don't see that as a reason to hold him up. But I defer to the commission, whatever you decide.
So, Tennessee Real Estate Academy, does it have a physical address?
Yes. I don't have the paperwork with me here, but yes. It's got to be apart from, I had a email discussion with a gentleman. I never talked to him personally, but that has to be apart from his real estate business.
Right,
So that's in place. That firm has a license?
No. Approving a course approves a provider.
The real estate school does not have to have a physical office. They just can't teach in a real estate office.
Correct. But they
I mean-
can't be a part of the firm.
Exactly.
Right.
Exactly.
So he's not going to be doing these classes in his company that he founded?
No.
But does it say, because, I mean, each month, and I think I brought it up last month, it says sponsor, address, and contact. So does the address, if we had an address, say where they are taught? Or it's just open, once they're approved, they can be taught wherever, as long as it's not in a real estate company?
They generally give us on the front end that the address or where they'll be teaching the first courses, but they don't, after that, we don't get that information. They could teach it all over East Tennessee.
And if you look on page 5, we already approved Life Academy Bible College. That's also a new provider.
That is a new provider this time. Right.
All right, other discussion on the motion to defer for 30 days. All right, since you're ready to vote, if you're in favor of that motion, you'll vote.
Second for that.
I've got one. Ms. Taylor seconded. If you're in favor of deferring for 30 days, you'll vote yes. If you're opposed, you'll vote no. Let's, just for the heck of it, call the roll to see how this works.
And just so we're clear, within 30 days, what exactly is it that you want us to
See if
gather?
the motion passes first. If it doesn't pass, we don't have to worry about it.
Yeah. Commissioner Rick Douglas,
Oh,
Commissioner Marcia Franks,
No.
Commissioner Diane Hills,
Abstain.
Commissioner Fontaine Taylor,
Yes.
Commissioner Bobby Wood,
Yes.
Chairman John Grease.
No.
3
So
to
that
2.
motion fails. We're back to the main motion, which is, as I recall, to approve both the instructor and the courses listed in the outline. Is there discussion on that motion? Are you ready to vote? Let's vote. Those in favor of that motion vote aye.
Aye.
Those opposed, no.
One abstention.
The motion passes on a 5 aye and 1 abstention vote. All right, next up is an update. I'm going to get to you in just a minute, Fontaine, on the
Oh.
Mississippi deal.
Okay.
We're still
okay.
on education.
Okay, good.
Update,
Education.
Trek Corps report. Mr. White.
Mr. Chairman, I prepared, and we have, I believe, the handwritten versions of the new 2019-2020 Trek Corps course that is being, every year about this time, we present that for your approval so that the providers can begin to prepare their courses. Thank you, ma'am. And it's up for your approval. There's hardly any change, just to point out, from the 2017-2018 version. Essentially that's just about the same, but I think that there's nothing new as far as rules to include. But the rules that we had back from the last Corps, I included them, but they're no longer new, but I thought they were pertinent. And for the rest, it pretty much tracks and mirrors what you saw before.
When you say pretty much, does that mean exactly?
Only one change on Roman numeral 1, Rule 1, and then let's see.
Residential?
Number 3. Out-of-state licensees must complete 16 hours CE for renewal. That was something that has become quite a question and answer for me and other members of the commission from folks who are out of state.
That's under residential?
That's, as far as I know, yes.
So it's
Both.
it's Rule 1
Number 3, all again.
every time? Oh, that 3. Okay. I move to approve.
Second.
Discussion.
On this, it says Roman numeral 8 says license recognition. No, what would that be?
I think we've done some changes in that. I would ask the director about that, but there's been some changes that we're putting out for the worksheet A. And so license recognition has to do with those folks who are coming to us from another state, that we would understand that they formerly held or hold a license in another state, and we get that information, and we have to review that and to be certain that they, in fact, are have that license as it relates to obtaining a license in this state. So that's my understanding of license recognition.
I think it's a little confusing for somebody though that was going to teach this class. I think that one needs a little bit more defining. I think the rest of it looks self-explanatory except for that one. Maybe it should be out-of-state license recognition.
I don't know that it's necessary either. The changes that we're making are internal; they're not external. It's more so just how we're handling their paperwork when it comes in, rather than so. To the outward-facing person, there should be no change. It should just be.
So we can just take that one out.
Take that one off.
Just remove that.
Okay.
Well, let me ask about that. So I have an agent who's just got licensed in Kentucky. I'm licensed in Kentucky, and he got licensed in Kentucky. And he had to take the state portion of the Kentucky test. He had, as I understand it, had to contact Trek to get the education that he'd done to satisfy his Tennessee license to make sure it was acceptable to Kentucky. He had to pay a fee. He had to buy a rider to his E&O policy. I don't know if that's anything we'd want to teach. I mean, I think it's probably just totally reciprocal. I mean, if somebody in Kentucky is trying to get in Tennessee, I think it's all about the same, isn't it? Fill out an application and do those things.
Yes, we asked them to get what we call certified history. So their certified history should be from the state that they're licensed in. It should show when they were licensed. It should show if they had any disciplinary history in that state. It should show the education that they've taken. Not word for word, but our requirement is that they meet or exceed our requirements. And so we review their education history and their certified history, and then based on that review, we tell them, you need to take the state portion of the exam, you need to get the 30-hour course. We tell them what they need to do, and that's done. We sent out a letter of communication on that.
It sounds important then.
Yeah, so like in Clarksville
People
or
would know that.
Chattanooga
We
or
have so many
Bristol.
surrounding states.
I get a lot of questions about that, and I really don't know the answer,
Yeah.
generally speaking, especially
Yeah.
on the commercial side. I don't know if it's a big deal residentially, but there are a lot of brokers who want to follow their tenants to town, and they want to get licensed. And now that really is not, I mean, this is a core class for Tennessee brokers, not Kentucky brokers. And so I'm not sure how that fits in. But
So, and this is my own curiosity because, so let's say we did include that. The rule is pretty, simple, just says meet or exceed. So as far as the process goes, is that something that we would disperse to providers?
Well, how do they get any of this information?
Well, the
Are we
licensee
dispersing all of it to them?
contacts us. Not, well, I don't know, Ross. How do you typically just send this out to?
Yes, we put it, once the commission approves it, then it becomes the next Trek Core. That's a required 6-hour course for the next 2 years in the educational cycle that'll end 12/31/20. And so it is communicated to them first by the website, and we may send out some type of blast to all providers, but they're all the ones that are interested in it are now clamoring to know that the commission has approved it so that they can begin to prepare their courses for the next 2 years. So, yes, we do get the word out to them.
We typically get this out to them in September. So I'm wondering, so if, and Bobby, maybe this would be a good question for Bobby as an instructor. under like Rule 1F, licensees who hold themselves out as a team, group, or similar entity within a firm, how would an instructor know what the commission wants or requires?
Well, usually what will happen at one of the schools, they'll have somebody, if it's a one-person school, or other places like associations will hire somebody to write the course.
Okay.
And then they'll write the course, then they'll submit the course to have it approved here.
Okay.
So it's their responsibility to go back and have somebody go through the rule book and put all that. It's not Real Estate Commission's responsibility. Tell them, you teach this rule.
Okay.
We're giving them the outline. It's their responsibility to put the meat to the outline.
Exactly right. It is an outline.
Yeah. And this, I'm jumping back to the license recognition. There might be some people that might be interested in that. That's such a small smidgen, and it really depends on each individual state. I mean, I don't think people, maybe in Clarksville might be interested in what Kentucky's doing. I don't think anybody in Memphis is, but they're probably Mississippi.
Yeah.
But what Mississippi does has nothing to do with what Kentucky does. They're completely independent
And
things.
Lawrenceburg would be of Alabama,
Yeah.
and Knoxville would be,
So but that's something that maybe if a school wanted to, they could turn around and they could add that to the material. They just can't. If it's on here, we got to put it in. That's why I'm thinking take it out, and then if a person who writes it wants to add it to it, hey, great. That's just more material they have.
That's fine with me. Maybe it's a newsletter item at some point. Just say,
Yeah.
We've had a lot of requests, and this is what you have to do, kind of thing. Perfect. So there's a motion, Mr. Franks.
And we're going to amend the motion to take out number 8, license recognition.
Which would be number 11 on commercial.
Yes.
We also have a broker core class.
Yes, but we have to approve this one because we require it. The broker, principal broker core class is different than this one because it's just something that people can take it voluntarily, but we also assign. And on that note, I talked with Steve McDonald this past week about that core class, and I told him that we're needing it to take place more often. And he says what TR is doing right now is getting that class where it can be taught in Kingsport, or it can be taught in Knoxville or Chattanooga or Memphis or wherever, and not just solely rely on TR for that class. And I told him that we needed it at a minimum of quarterly, if he could get that for us quarterly. So
My question about the broker core class is, does it satisfy the requirement to take a 6-hour core class every 2 years?
I believe we'd have to see what the commission ruled on that several months ago when that course, last year, when the course first was presented. But I believe the ruling was that, yes, we would allow that for the 6 hours, although I believe it's an 8-hour course, and the other 2 hours could just fall within the elective. But
could you put that on next month's agenda, just to be certain? Because if it is a requirement, if it satisfies the core requirement, then we ought to approve the agenda for that, or the outline for that as well, I would think. In the meantime, the motion on the floor is to approve the outline related to the Trek Core Commercial class and the Trek Core Residential or Basic Core class for 2019-2020, as submitted by the Executive Director, with the exception of pulling the license recognition item off of that outline. Further discussion. Let's vote. Those in favor of that motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Thank you, Mr. White. Stand by. Ms. Taylor has a question or a topic she'd like to discuss.
thank you, Mr. Chairman. Yes, sir.
Right. Mr. White, I've had multiple calls recently about people from Mississippi mainly surprised when they go to renew their license that some of the courses they've taken in either Mississippi or Tennessee are not recognized by either state.
Yes, ma'am.
And of course they asked me, and I said, I'm not, I'm out of this one. I don't know the answer to that. Mississippi, as I understand it, accepts Tennessee courses, but Tennessee evidently is not accepting all Mississippi courses. And so what's the rule on that, and how does that work with our states around us?
Well, back last June, I believe the commission decided at the Collierville board meeting that we would no longer, that rather than acquiescing, we would follow legal advice that we would not accept out-of-state courses, that rather we don't reciprocate in any version anyway, that rather an individual who holds an out-of-state license with our Tennessee Real Estate Commission must complete the same 16 hours of approved education that in-state realtors have to. So that being said, a letter went out to all that were in the system at that time by the legal office. It had my signature on it, but it was written up by the legal folks that expressed that if when they renewed past September of last year, if their renewal fell past September 2017, they would have to do 16 hours of Tennessee approved education. And so that letter went out and so generated lots of confusion and questions, and I still get questions. I'm sure members of the staff still get questions, but that's what we've held, and that's why I put it on the TREC Corps, to digress a minute, so that it's understood that is a requirement now. Recently, a couple of weeks ago, I got a same request from an individual who was asking about it, and I explained it to them, and I think it went on to their Mississippi Real Estate Commission, that's the way Tennessee's handling it. So I believe they may change their commission. I can't speak for them. I don't know, but I think that may be in the works.
Definitely.
But it was understood, and I regularly send out communications explaining this, that we no longer take the Mississippi or the Arkansas or whatever, that they have to complete the Tennessee before, and they have ample knowledge of, they should have, when their license is renewed, they have to have that 16 hours of Tennessee approved education prior to that renewal.
And including the core class, that 16 hours.
The 16 hours, 10 hours is elective, 6 hours is the core.
But just to make sure that if you have a contracts class, for instance, or that's certified by Tennessee, if you take a contracts course in Mississippi, it's not the same thing. That's correct, unless that course is certified by Tennessee.
Right. You have to have a Tennessee-approved provider teaching a Tennessee-approved course that the commission has approved.
Right. Thank you. I think we got it. I just wanted that on record so that people would understand it.
Bobby?
But one other thing, too, to keep in mind, a lot of times you can take a class, a lot of these bigger education providers, they'll get a class approved in Mississippi, Tennessee, all kinds of places, and I've been in those classes before, and then they'll say, okay, if you want Tennessee, we've got everybody's name, we're turning into Tennessee. If you would like Mississippi credit, we'll charge you $10, and then we'll do the paperwork and send it in. Right. And so you don't have to sit through the material again. You just pay basically a fee for them to turn it into that commission. So.
Right.
That class would have had to have been approved and that instructor
Exactly.
through us prior to.
Exactly.
I recall, Fontaine, that Sue brought this to our attention in Collierville, and that basically there were Tennessee real estate agents who were upset that they were having to take 16 hours, but the Mississippi agent practicing in Tennessee didn't. And
that is correct.
And that was the genesis.
Well, I couldn't remember the exacts of it, but I think there's still a lot of misunderstanding. So,
one caveat, and that is in that same letter that went out, it explained that if they're a broker that held the Tennessee license, though they're out-of-state license holders, if they're a broker prior to 2005, then they would be grandfathered in. Or if they were an affiliate in 1980, it goes back a ways, then they would be grandfathered in. So that grandfathering is still available to them.
I would hope that we could put that again in our newsletter or something, so it would go out to at least our Tennessee people, so they have current knowledge of it.
All right. Ms. Franks.
I wanted to ask you, Mr. White, if Arello approves of class, are you checking to see if any of the classes are approved by Arello?
Yes, ma'am.
Okay. And
Yes.
so can you let us know, like, if there's something that we're not sure about on a class, if I knew that it had been approved by Arello, that would probably sway my vote to say, okay, it's been approved by Arello?
Yep, Commissioner, and when it's just that little, all these little things as I review, but when it's a classroom course, then you'll see out beside of the title of the course that it's CR. And if it's an internet course, and that's, in our law, it's known as a distance course, then that little internet will be out beside of the course. When that's there, then I have reviewed to see that they have an Arello certificate and that they have an Arello approved CDEI holder that can teach the course.
Okay, and I also wanted to ask you that I contacted Ms. Maxwell about this, about the renewals of courses, and is the process going to be electronic or not?
We've got a bifurcated system this time.
What?
Well, we've got a two-part
Bifurcated.
system. We've got the courses.
I went to Antioch. What do you mean?
we got two things. The first thing with the courses, we had hoped we would have that an online renewal system this time, but unfortunately, in working with IT and with the resources that we currently have, probably not going to happen this time. But we have streamlined the process so that we're going to be stuffing envelopes and sending them out tomorrow to all providers, the 250 plus active providers in the state. We'll send them out, and they're going to have boxes with their courses on them to check which ones they want, and the form will be attached, the renewal form. They'll send those back in, and we've met with our physical office and with our IT folks to get all this lined up. So it's going to be a streamlined process from what it was last year.
Okay. All right.
And then as far as the instructors, that's bifurcated. The second part of this is
I never got that definition. What's bifurcated?
There are two answers to your question.
Okay,
Provide
thank you.
them.
Okay. I learned something.
the second part, the instructors, we're also going to send them out the same, but we'll send it out by mail as far as the instructions, but they will be online this time.
Okay.
So that is a good thing.
Now, and so can providers advertise and collect money before a class is approved? Is there any rule or anything on that? Might be an attorney question.
They should not be advertising prior to approval. Now, they might advertise that this course is coming before the commission in September for potential CE or something of that nature, but they shouldn't be saying, you're going to get your credit. That would be a false advertisement because it hadn't been approved yet.
I agree. They should not be doing that until the course is approved by the commission.
Okay, so what could we do? What could we do about that? Because that's happening. That's happening.
If someone were to notify us, we could send a letter or make a phone call and tell them to cease from doing that.
Well, I'm just wondering proactively if there was something we could let them know. Don't be advertising it until it's approved. I think that would be the better thing to do. And if they've got the money, they've got the money. And if we don't approve the class, there's a problem. It would just be a suggestion, maybe a rule or something.
Well, I think Ross could probably also communicate that when he receives the application.
Okay. And Ross, are you communicating that no products or services may be sold or represented at any of the education classes? I noticed that on some of the ones that we approved today, that they had not taught any classes before, and some of them are about abatements and those kind of things. I'm just wondering, I just want to be sure that we don't have just people who are trying to sell their mortgage company or whatever. Realtors do not like that. Licensees do not like that when they go to a class and they're basically being sold something.
Right.
If you could let them know that also.
Yes, ma'am.
Okay.
Well, there's a difference between a sponsor who provides donuts and coffee, right? Who gets
Yeah,
5
the sponsor
minutes.
usually gets 5 minutes and they get to say something about their company. I'm not opposed to that at all. I'm opposed to the instructor that's getting up there telling you that if you need smoke abatement, you need to call my company. If you need odor abatement, you need to call my company, that kind of thing.
What I usually find, those things get taken care of because there will be somebody in that classroom that heard that and didn't appreciate that, and they'll usually send word in, and that'll get stopped real
To their
quick.
association or something.
Yeah. I've not seen that being a problem. Now, what does happen and why instructors would do that? If I had a home inspection company, I'd go and give the best class I could on being a home inspector, and then somebody goes, "Man, that was a really informative 2 hours. Can I get your card?"
Yeah.
I mean, that's the whole purpose of
Yeah.
it. And
So the only nefarious, have you heard that word at Antioch, nefarious?
I'm sorry, I should have never said that.
we didn't hear that at DuPont either.
I apologize.
So I've been
To all
told
Antioch friends.
by different brokers that competitors occasionally infiltrate an education class to try to recruit people even before they're licensed to their firm. And they might do that by having a mole in the class or providing lunch during break for the whole class with the banner of a company. What are our thoughts about that?
Well, those sort of things should not be taking place because our rules and laws are fairly explicit that the any type of undertaking of the business, of the real estate business, should be separate and apart from the education business. And that is understood. I get communications from providers who really understand that, though they may have a nuance they want to ask me about, but I always tell them that you've got a separate, it has to be that way. The law mandates it to be that way. And so if they have that sort of thing, I haven't had it reported that somebody's trying to drum up business or that sort of thing, but it is understood that is not, it's prohibited to do that.
Thank you.
So if we know of a company that's doing it, my daughter got her license 3 years ago, and every day there was a different real estate company that brought lunch in for them. It happens all the time.
Get invited. They decide what company gets invited to
Right.
meet these new affiliates and provide something.
I think the only way to handle that would be to get a complaint. Somebody file something with us and let us know.
And usually those new in-class students don't know that they can file a complaint about something like that. So, just something to reiterate it to those schools.
And,
Well, I'll let you
why
know
it's
which one
so
I'm talking about
important.
later.
Why it's so important? Because it's we're not we're not approving the school. The only thing is
Would
Okay, I've never been able to get in and do one of those lunches, but my question is, what's wrong with that? I mean, if they're doing at lunch and they're doing lunch, I mean, I've had schools before we've called and said, "Hey, can we come and kind of try to have a social hour afterwards?" And they're like, "Look, we're not going to get instruction out of this. We take breaks. You're welcome to stand out in the hallway during the breaks, And I said, "Well, how about lunch?" And they said, "We got lunch, but we really try to just hurry and go on so we can move on through the day, and if we really don't have a structured lunch." And so, I mean, I don't see that I guess I'm on the wrong side of town, Marsha. We didn't do it that way on our side. But if it is at lunch, I don't see a problem with that. The problem would be if they're in the classroom doing it, But
I think you just have to avoid the appearance of impropriety.
yeah.
That pursuant to the law and the rules, you got to have to be separate. It's understood that way. And any incidental things that could happen, I think you have to avoid that ethical consideration there of, are you breaking the law or the rule?
All right, other questions for Mr. White? We've put you through, well, not the ringer, but you've had more than your fair share of time in front of us today. We appreciate your responses. Thanks, Ross.
Thank you, Mr. Chairman, members of the commission.
All right, Ms. Matlock, legal report. What do you have for us?
I have an update for you guys. as you know, the Fresh Start Act passed in July, and we've noticed one of our rules, if you look at Rule 1260.01.014 on page 67 in your red books, it's the rule for applications for examination. It states that no person shall be eligible for examination or be considered for licensure unless 2 years have passed from the date of expiration of probation, parole, or conviction, or from the date from release of incarceration, what is later in time. And this restriction applies to all felonies and to misdemeanors that involve theft, money, services, or property. And in looking at that rule, we have made the determination that we believe that the language of all felonies and misdemeanors falls within the Fresh Start provision. So if we were to have an individual that were to apply and would fall into that category of not being past 2 years probation, we would believe that that would be a decision that you guys would need to make, whether an individual is allowed to proceed in the licensure process. Normally, we would just go ahead and deny that application, but we've decided before, if that were to happen, if someone were to come to us, we would bring it before you, let you know the facts, and make your determination whether or not you believe that individual should continue with licensure.
Because we have one of those
process.
cases this morning.
We do. So I would like to present that to you to make your determination before we were to go through it. I need to make sure this would be okay with you.
All right, so I want to ask Bobby Wood to say back to you what you just said to him.
I have no idea what she just said.
Would you like me to?
My guess is we got a rule, but basically we're saying because of something that's come down from higher up than us, we're not going to go by this rule. Anybody who's just got out of parole or anything, they can come and apply to us and ask us to basically waive this rule.
Well, we are going by the rule, but there are certain carve-outs in the Fresh Start Act. There are certain convictions that we're supposed to apply more attention to. For a specific instance, this one is possession of cocaine. So that's not something that necessarily falls within our enumerated convictions. So because of that, we figured we would bring it before you to make a determination whether or not you would like this person to proceed with the licensure process.
So I'm going to try to restate what you said.
Okay.
Our rule that you quoted, 1260, was it 1260.01.4, whatever that number was,
014.
is trumped by legislation.
Yeah, we believe that the legislation would apply to this rule, yes.
A fresh start has been passed in the legislature.
Yes, it went into effect July 1st.
So instead of you unilaterally telling an applicant 2 years haven't passed, come back in 2 years or when that 2 years is up, instead you're going to look at it and see what the particular crime was. And if it falls within a certain category, you're going to bring it to us and let us exercise our judgment on whether
Yes,
they
you'll
should.
make your discretion. It will be up to your discretion to make that determination.
But we need to base that discretion on some sort of guideline, right? Does Fresh Start speak to what causes us to?
We would only have to go through the Fresh Start analysis if you were to decide that person should not proceed with licensure.
Well, then we should go through it each time, I would think. I wouldn't want them to say they couldn't do it and then go through the analysis.
Well, yes. I mean, I don't believe necessarily that you would have to go through that analysis. Like if I were to present the facts to you and that was something that you would already decide, okay, this is all right, I don't think that you have to have that discussion on the record. But if you were to decide, no, we don't want to do this, then we would need to have that discussion.
So the discussion, if we said no, then we would justify why we said no.
Yes.
And there are guidelines that cause us to say no, or is it just a feel for us at that point?
There are, of course, the threshold question would be is if this criminal conviction directs relatedly to the real estate profession. And then if you decide yes, then we would go through the 6 factors following that.
So regardless of the length of time that they've been off of parole or probation, even if it's 1 day, It wouldn't matter in certain instances as set forth by the legislature?
Yeah, we believe that it would come, but like the reason is we've had an applicant that came before us with this, and then we made a determination that we believe this falls within the Fresh Start Act. It's because of the specific, I guess, conviction, and this because the Fresh Start directly addresses drug convictions as something that we should consider.
But why would you bring them before us in the first place then? Is that something that you can just say it's not on the this is not on the list, so they don't need to go before the commission? Why waste the time of that person or the commission if it's on your list of approved convictions?
They have to come before the commission if they have a felony or if they have a misdemeanor. That is one of the charges that's enumerated in
But
the
if
chapter.
their felony is not on that list,
It's any felony. Any felony.
Our rule says any felony,
Okay.
which is more broad than what is provided in the Fresh Start Act.
We're going to have a trial run at this today? Yes. Okay.
So I just wanted to provide I'll provide the facts to you, and then you guys can have a discussion and then make a determination whether or not you would like this person proceed with licensure.
So just so we're clear, you're going to present the facts. Commission's going to discuss whether we want this person to be allowed to go ahead and get a real estate license. If we say yes, we're done. Let
If we
them go.
say yes, then we would have this person proceed. However, in this particular instance, this person, based on their credentials, would have to come for an informal appearance.
So let's say we say no,
Yes.
at which point you're going to run through a list of
Factors,
6 or 7 factors.
and we'll have to have that discussion on the record.
and then we vote.
We've already voted, is what I'm,
If you say no, then we would have to go through the 6 factors, and then you've already voted no. We just need to have that discussion on the record, and then we would notify the individual of your decision in accordance with the Fresh Start Act.
so after all this discussion, you will keep us in line, correct?
Could we possibly get a list of those exceptions?
Factors.
Of the exceptions?
Yeah.
We have a copy of the Fresh Start Act. I can give it to you. It's just the one. I don't have multiple copies. But
If you could just give us a list of what's not, I see no reason in wasting our time to vote no on something, and then you say, too bad it's on the list. I would rather know too bad it's on the list before we voted.
Well, it is, which is why I've brought it to your attention.
Okay, that's
today.
why I want the list.
Okay. Hold on
All
a
right.
second.
Diane?
So just to be sure, so there are possibilities that we would not have to wait on the 2-year probation period to pass because of the Fresh Start Act.
Correct.
Just want to be sure. Except for these exemptions that Commissioner Franks has asked for.
I would just note that really the only difference with the person that you're going to see later today is that their 2 years of probation have not lapsed. Otherwise, this could be any informal appearance coming before you. We would still have to apply the Fresh Start Act to anybody that's an informal appearance that falls under those guidelines that you potentially don't think should be licensed.
And do you think the legislation has a bias or preference that if it's drug-related, we should show leniency relative to other felonies?
I don't think so necessarily. It just is bringing to attention that those are certain convictions that you guys should take a second look at and not just automatically deny someone based upon that.
So the state is saying to us, we could vote to not allow that person, even if it's something on the Fresh Start list.
But yes.
Okay. And then you just have to give us the lecture about the Fresh Start, even after we voted no.
Right.
But the vote would still hold. Or would we have to revote?
We could revote, I guess. We could reconsider.
What about him?
It's-
So you still have the discretion to say no. That is within your board's like purview. You still can do that. But if you say no, we have to have a discussion on the record about why you're saying no.
Who was that guy whispered in your ear anyhow? I mean, why didn't he? Did he not want us to hear him, or what? Denard, what is the deal, buddy?
I would also note the one person that you've said no to in the last couple months, they wouldn't apply to the Fresh Start Act because you said no based on charges that they had in another state given by another commission. So that person wouldn't have, it was before the Fresh Start Act started, but it wouldn't have applied anyways because they weren't.
Yeah, the Fresh Start Act applies to criminal convictions solely.
I've got a sense that this commission and the three members who aren't here today will test your patience on this. So if you will work with us, we'd appreciate it.
Yes, of course.
All right, what else in your legal report, Anna?
So I just wanted to present it to you so we can make a vote.
Else you want to mention at the moment?
No, that's it. This is the only thing.
All right, let's go to this medical waiver, Caitlin, and see what we can do with this.
So last month you had asked for a more specific doctor's note for this individual. You wanted it from the specific doctor, and you wanted more detail. And we reached out a couple of different times to try to obtain that over the last month. And I'm not saying we might not get it next week, but we did not get it in time for this meeting.
All right, Commissioners, is there a motion to maybe postpone this for another month? If not, is there a motion to deny the request, to approve the request?
So after our last meeting, we asked for some more information. You contacted them, and they've not felt it's important enough to get back to you?
So the last we heard, they were going to the doctor and they were going to get the additional information.
When was that?
Last week. We had communicated some after the meeting, and then we spoke to the person again last week, and they were going to the doctor at the end of the week, and they were going to send it to us. They also told us they were going to be out of town this week. So we did attempt to get the doctor's note, and I even...
But if we just talked to them a week ago, is that right?
I think we talked to them prior to that.
Okay.
They just responded a week ago.
Yes, they just confirmed a week ago that they were getting the doctor's note at the end of last week.
I would make a motion that we show a little mercy here and give them 30 more days, but you can tell them that's it.
Okay.
30 days.
Okay.
I've got a motion by Ms. Frank, seconded by Ms. Hills, that this item be deferred until the October meeting. Further discussion. All right, let's vote. Those in favor of that motion vote aye. Those opposed, no. The motion passes unanimously. All right, guys, I think at this time we'll take about a 10-minute break and come back and catch up with this woman named Karen Lowe, whoever she is. All right, guys, 10 minutes, we'll be back.
Do we not have to fill out those sheets?